Title II, 124 to 133 Crimes against the Fundamental Laws of the State. Chapter 1, Arbitrary Detention or Expulsion, Violation of Dwelling, Prohibition, Interruption, and Dissolution of Peaceful Meetings and Crimes against Religious Worship. Section 1. Arbitrary Detention and Expulsion. Article 124. Arbitrary detention. Any public officer or employee who, without legal grounds, detains a person, shall suffer 1. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period, if the detention has not exceeded 3 days. 2. The penalty of prison correctional in its medium and maximum periods, if the detention has continued more than 3 but not more than 15 days. 3. The penalty of prison mayor, if the detention has continued for more than 15 days but not more than 6 months, and 4. That of reclusion temporal, if the detention shall have exceeded 6 months. The commission of a crime, or violent insanity or any other ailment requiring the compulsory confinement of the patient in a hospital, shall be considered legal grounds for the detention of any person. Elements. That the offender is a public officer or employee. That he detains another person. That the detention is without legal grounds. The public officer liable for arbitrary detention must be vested with authority to detain or order the detention of person accused of a crime, but when they detain a person they have no legal grounds therefor. If the crime is perpetrated by other public officers, the crime committed may be illegal detention, because they are acting in their private capacity. But private individuals who conspired with public officers in detaining are guilty of arbitrary detention. When is there detention? Detention is defined as the actual confinement of a person in an enclosure, or in any manner detaining and depriving him of his liberty. Detention is without legal grounds, when 1. When he has not committed any crime or, at least, there is no reasonable ground for suspicion that he has committed a crime, or 2. When he is not suffering from violent insanity or any other ailment requiring compulsory confinement in a hospital. Warrantless arrest. Arrest without a warrant is the usual cause of arbitrary detention. Except a peace officer or a private person may, without a warrant, arrest a person. 1. When, in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. 2. When an offense has in fact just been committed, and he has probable cause to believe based on personal knowledge of facts and circumstances that the person to be arrested has committed it, and 3. When the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. Article 125. Delay in the delivery of detained persons to the proper judicial authorities. The penalties provided in the next preceding article shall be imposed upon the public officer or employee who shall detain any person for some legal ground and shall fail to deliver such person to the proper judicial authorities within the period of 12 hours for crimes or offenses punishable by light penalties, or their equivalent, 18 hours for crimes or offenses punishable by correctional penalties, or their equivalent, and 36 hours for crimes or offenses punishable by afflictive or capital penalties, or their equivalent. In every case, the person detained shall be informed of the cause of his detention and shall be allowed upon his request, to communicate and confer at any time with his attorney or counsel. As amended by EONOS 59 and 272, November 7, 1986, and July 25, 1987, respectively. Elements. That the offender is a public officer or employee. That he has detained a person for some legal ground. That he fails to deliver such person to the proper judicial authorities within 12 hours for crimes or offenses punishable by light penalties, or their equivalent, or b. 18 hours for crimes or offenses punishable by correctional penalties, or their equivalent, or c. 36 hours, for crimes or offenses punishable by afflictive or capital penalties, or their equivalent. Article 125 does not apply when the arrest is by virtue of a warrant of arrest. The delivery to the judicial authority of a person arrested without warrant by a peace officer does not consist in a physical delivery, but in the making an accusation or charge or filing of an information against the person arrested with the corresponding court or judge XXXXX. Sao v. Cop of Manila. Article 125 distinguished from Article 124. Arbitrary detention. Under Article 124, detention is illegal from the beginning. Tn. Not applicable if the detained person are detained under RA 9372. Arbitrary detention. Under Article 125, the detention is legal in the beginning, but the illegality of the detention starts from the expiration of any of the periods of time specified in Article 125, without the detained prisoner having been delivered to the proper judicial authority. Article 126. Delaying release. The penalties provided for in Article 124 shall be imposed upon any public officer or employee who delays for the period of time specified therein the performance of any judicial or executive order for the release of a prisoner or detention prisoner, or unduly delays the service of the notice of such order to said prisoner or the proceedings upon any petition for the liberation of such person. Acts punished. By delaying the performance of a judicial or executive order for the release of a prisoner. By unduly delaying the service of the notice of such order to said prisoner. By unduly delaying the proceedings upon any petition for the liberation of such person. Elements. That the offender is a public officer or employee. That there is a judicial or executive order for the release of a prisoner or detention prisoner, or that there is a proceeding upon the petition for the liberation of such person. That the offender without good reason delays, 1. The service of the notice of such order to the prisoner, or 2. The performance of such judicial or executive order for the release of the prisoner, or 3. The proceedings upon a petition for the release of such person. Wardens and jailers are the public officers most likely to violate Article 126. Article 127. Expulsion. The penalty of prison correctional shall be imposed upon any public officer or employee who, not being thereunto authorized by law, shall expel any person from the Philippine Islands or shall compel such person to change his residence. Acts punished. By expelling a person from the Philippines. By compelling a person to change his residence. Elements. That the offender is a public officer or employee. That he expels any person from the Philippines, or compels a person to change his residence. That the offender is not authorized to do so by law. Only the court by final judgment can order a person to change his residence. This is illustrated in ejectment proceedings, expropriation proceedings, and in the penalty of destierro. Section 2. Violation of domicile. Article 128. Violation of domicile. The penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who, not being authorized by judicial order, shall enter any dwelling against the will of the owner thereof, search papers or other effects found therein without the previous consent of such owner, or having surreptitiously entered said dwelling, and being required to leave the premises, shall refuse to do so. Qualifying circumstance. If the offense be committed in the night time, or if any papers or effects not constituting evidence of a crime be not returned immediately after the search made by the offender, the penalty shall be prison correctional in its medium and maximum periods. Acts punished. By entering any dwelling against the will of the owner thereof, or by searching papers or other effects found therein without the previous consent of such owner, or by refusing to leave the premises, after having surreptitiously entered said dwelling and after having been required to leave the same. Elements. That the offender is a public officer or employee. that he is not authorized by judicial order to enter the dwelling and / or to make a search therein for papers or other effects against the will of the owner presupposes opposition or prohibition by said owner whether express or implied. If the entrance by the public officer or employee is only without the consent of the owner of the dwelling, the crime is not committed. Neither is the crime committed if the owner of the dwelling consented to such entrance. People v. Louis Saint. Article 129. Search warrants maliciously obtained and abuse in the service of those legally obtained. In addition to the liability attaching to the offender for the commission of any other offense, the penalty of arresto mayor in its maximum period to prison correctional in its minimum period and a fine not exceeding 200,000.00 pesos shall be imposed upon any public officer or employee who shall procure a search warrant without just cause, or, having legally procured the same, shall exceed his authority or use unnecessary severity in executing the same. Acts punished. By procuring a search warrant without just cause, by exceeding his authority or by using unnecessary severity in executing a search warrant legally procured. Elements of procuring a search warrant without just cause: that the offender is a public officer or employee, that he procures a search warrant, that there is no just cause. Search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. Personal property to be seized: a subject of the offense, b. stolen or embezzled and other proceeds or fruits of the offense, c. used or intended to be used as the means of committing an offense. Elements of exceeding authority or using unnecessary severity in executing a search warrant legally procured: that the offender is a public officer or employee, that he has legally procured a search warrant, that he exceeds his authority or uses unnecessary severity in executing the same. Remember, e.g. searching personal effects having a remote or no connection to the subject/charged, e.g. destroying furniture without justification. Article 130. Searching domicile without witnesses. The penalty of arresto mayor in its medium and maximum periods shall be imposed upon a public officer or employee who, in cases where a search is proper, shall search the domicile, papers, or other belongings of any person, in the absence of the latter, any member of his family, or in their default, without the presence of two witnesses residing in the same locality. Elements: that the offender is a public officer or employee, that he is armed with search warrant legally procured, that he searches the domicile, papers, or other belongings of any person, that the owner, or any member of his family, or two witnesses residing in the same locality are not present. Exception: for Tariff and Customs Code violations. Search without warrant under the Tariff and Customs Code does not include dwelling house. Section 3. Prohibition, interruption, and dissolution of peaceful meetings. Article 131. Prohibition, interruption, and dissolution of peaceful meetings. The penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who, without legal ground, shall prohibit or interrupt the holding of a peaceful meeting, or shall dissolve the same. The same penalty shall be imposed upon a public officer or employee who shall hinder any person from joining any lawful association or from attending any of its meetings. The same penalty shall be imposed upon any public officer or employee who shall prohibit or hinder any person from addressing, either alone or together with others, any petition to the authorities for the correction of abuses or redress of grievances. Acts punished: by prohibiting or by interrupting, without legal ground, the holding of a peaceful meeting, or by dissolving the same. By hindering any person from joining any lawful association or from attending any of its meetings. By prohibiting or hindering any person from addressing, either alone or together with others, any petition to the authorities for the correction of abuses or redress of grievances. Elements: that the offender is a public officer or employee, and that he performs any of the acts mentioned above. Note: only public officers can commit this crime. To constitute a violation of the first PAR of Article 131, 1. The meeting must be peaceful, and 2. There is no legal ground for prohibiting or interrupting or dissolving that meeting. The offender must be a stranger, not a participant in the peaceful meeting. Section 4. Crimes against religious worship. Article 132. Interruption of religious worship. The penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who shall prevent or disturb the ceremonies or manifestations of any religion. If the crime shall have been committed with violence or threats, the penalty shall be prison correctional in its medium and maximum periods. Elements: that the offender is a public officer or employee, that religious ceremonies or manifestations of any religion are about to take place or are going on, that the offender prevents or disturbs the same. If the crime is committed with violence or threats. Article 133. Offending the religious feelings. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period shall be imposed upon anyone who, in a place devoted to religious worship or during the celebration of any religious ceremony, shall perform acts notoriously offensive to the feelings of the faithful. Elements: that the acts complained of were performed, 1. In a place devoted to religious worship, or 2. During the celebration of any religious ceremony. That the acts must be notoriously offensive to the feelings of the faithful. Religious ceremonies are those religious acts performed outside of a church, such as processions and special prayers for burying dead persons.